Hello and welcome to the AIFC Court and International Arbitration Centre Webinar Series 2020, New Opportunities During and Post-COVID-19. Today we have webinar 13 in our 2020 series. The topic is Legal Responsibility for the Wrongs of Others. Who pays and in what circumstances? Today's speaker is Justice Lord Faulks QC, one of our most distinguished judges at the AIFC Court. We have 1 hour for today's webinar. Lord Faulks will give his presentation and we will then open the floor for questions. Please type your questions if you have any in the Q&A option, which is shown at the bottom or the top of your screens, and Lord Faulks will answer the questions at the end of his presentation. Before we start, a very quick update from me as usual, if I may, and that is to the effect to remind you all that at this stage, the Court and Arbitration Centre still continue to provide all of our services 100% online without any disruption whatsoever. We have, as of today, administered a total of 90 cases across the Court and Arbitration Centre. This comprises judgments and orders, arbitration and mediation awards. All of these services have been and will continue to be provided free of charge until 2022. In addition, we've of course got our 2020 webinars programme, which now includes 20 webinars from our judges from the Common Law AIFC Court, our arbitrators and leading lawyers from Kazakhstan. So without further ado, if I may, I'll hand over to our speaker, Justice Lord Faulks.
Hello, thank you very much, Chris, for that introduction. The AIFC Court, of which I have the privilege to be one of the judges, has the jurisdiction to decide civil disputes in accordance with English common law. Now, as you've heard from Chris, the court's workload is gathering pace with a number of disputes which have been decided, will be decided in the short, medium and long term, but has not yet established a large body of its own precedents so as to give litigating parties an indication of where court might approach a particular point of law that comes before it. So that in the meantime, the court is likely to look to the law in England and Wales for the common law. And I want to discuss today an area of law, what's known as vicarious liability, which has given rise to a considerable number of decisions in the courts in this country in recent years. Most notably, 2 decisions of the Supreme Court this year, in April 2020, just after this country had locked down, which have provided some, if not total, clarity as to the law. Now, the law in relation to vicarious liability has considerable practical importance in a number of different situations. But one of the reasons I thought it might be useful to talk about it today is that it's a very good example of the way that judges make law and of the operation of the doctrine of precedent, one of the defining characteristics of the common law. And I want to trace very briefly the history of vicarious liability and how the doctrine has responded to changing commercial practices and indeed attitudes in society. Now, in commercial disputes, the obligations of the parties are generally determined in accordance with the terms of the relevant contract, and the applicable law will often have been chosen by the parties and incorporated into those contractual arrangements. But on occasions, a company's employee may do some wrong, a tort, whether negligent or even fraudulent, and cause damage to the employer and possibly to third parties. The employer may be entirely ignorant of that wrong, and indeed, had they known, they would have done everything they could to prevent it happening. However, the employee would not have been in a position to do what he did if he'd not been employed. And if a third party suffers as a result of those acts or omissions, why should that third party have to sue the individual who may not have sufficient resources to satisfy any judgment, rather than seek compensation from his employer, who will probably have what is known in the law as deeper pockets, and of course would be the reason for the employment in the first place. Now, the law dealing with this issue goes back a very long way. Some people say it even goes back to Roman times, when the issue was whether somebody was responsible for the acts of their slave. Judges in the early cases in this country used the expressions master and servant. The question for the courts was always, in what circumstances was a master liable for the wrongs of his servant? Now, the question and the relationship is that of employer and employee. But the fundamental issue is the same. Is an employer liable for the torts of his employee? And what are the relevant pointers as to when there will or will not be vicarious liability? Now, if an employee was at the material time acting in the course of his employment, then there would be liability. But if, to use an old-fashioned phrase, which the courts adopted, he was on a frolic of his own, then the employer would not be liable. Now, there were plenty of cases that were close to the margins, and courts looked at the particular facts and decided whether what the employee had done was sufficiently close to result in there being liability. Now, Parliament could have intervened on the law, but clearly they thought, or at least they hadn't got the inclination to interfere. They obviously thought it was reasonably satisfactory. And in fact, in the Occupiers Liability Act in 1957, where Parliament was trying to clear up some rather muddled distinctions in the common law about the position when liabilities might or might not accrue to an occupier, they actually incorporated in that law one of the principles of vicarious liability, and we'll come to this in a little more detail later, which is that an employer would not be liable for the torts of someone engaged by him as an independent contractor. Now, for many years, corporations and other employers organized their affairs, and of particular importance made their insurance arrangements on the basis of the law as I have set it out. But all that changed nearly 20 years ago. And perhaps we could have the first slide now. The case that changed everything was Lister and Hesley Hall in 2001. That case was concerned, as with many that followed, with liability for sexual abuse. Although the courts have frequently reiterated that the law in relation to vicarious liability is no different, whatever the nature of the wrong which is at the centre of the case. In Lister, the claimants were sexually abused by the warden of a small boarding school for children who presented particular challenges. The law had been that where someone committed a criminal offence, what they did was so far removed from what they were employed to do that it would not be fair to saddle an employer with responsibility for those acts. And the other case which you have on that slide is a Trotman versus North Yorkshire County Council, which represented the orthodox view of the law at the time. But the House of Lords in Lister took a different view. And I should explain that the House of Lords Appellate Committee was in effect the Supreme Court, although it did not become so until about 10 years ago. It was the final court of appeal, the highest court in the land. Now, what was decided in Lister was that vicarious liability could exist in circumstances where even if an employee had committed a deliberate tort, and in a criminal offence indeed, there was a sufficiently close connection between the employment and the tortious act. So that if this, as it was the case in Lister, if the warden's whole reason for being there was to look after vulnerable children, his abuse of them, it was considered, was sufficiently connected to make it appropriate for there to be vicarious liability on the part of his employer. Although the court also said it wouldn't be the case, for example, with the groundsman, whose main task was to look after the grounds, of course. Now, the decision in Lister had been considerably influenced by various decisions of the Canadian Supreme Court, which had adopted a far more open-textured approach to liability, in effect concluding that where large organisations were concerned, particularly connected with the church or education, and they had effectively rendered the abuse possible. And even if they hadn't actually been negligent in permitting it, there was no good reason why they shouldn't be liable. In fact, Lister didn't go quite as far as the Canadian cases, but what clearly emerged was that in order to establish liability, a close connection, whatever that meant, had to be established. Now, unsurprisingly, quite a number of cases followed Lister, where the issue in each case was whether the employee's wrongdoing was or was not sufficiently connected with his employment. And what emerged from those cases was that there were in effect two stages to the analysis. Stage one was whether or not there was actually a relationship of employer and employee, and stage two was the so-called close connection test. Now, one of the first cases which dealt with stage one was a case called E versus English Province of Our Lady Charity in 2012. And it was a case that concerned a priest, who had abused a child, who was appointed by a diocesan bishop. And the question was whether the relationship was, and I use the words advisedly, akin to employment. Now, the priest relied on the goodwill of parishioners for his income, and the bishop's actual control of his activities was very restricted. And there was a lot of reference to canon law in the judgments. However, the Court of Appeal in that case concluded that the law on vicarious liability, quote, has moved beyond the confines of the contract of service, end quote. Contract of service being a strong indication that a conventional employment situation existed. But the Court of Appeal did note that the law still remained that an employer was not vicariously liable for the torts of his independent contractor. Now, the Court of Appeal decision had been very much influenced by the other case, which is on this slide, Catholic Child Welfare Society and various claimants, which is usually referred to as the Christian Brothers case. Now, this was another case about sexual abuse, this time by brothers in a school who were not employed by the Christian Brothers in a conventional sense, but were sent there with a mission to teach and to instruct on religious matters. Now, in reversing the decision of the lower courts, who'd found that there was no relationship of employment there, the Supreme Court looked at the various indicia which they said existed. And this is a direct quote from the speech or the judgment of Lord Phillips, the President of the Supreme Court, who said that when you're deciding whether or not there is vicarious liability, you look at these 5 factors. Now, I won't read them out. You can have an opportunity to look at them. They're all different indications, it is said, as to when there will be vicarious liability. But of course, applying them can prove difficult, and the Supreme Court did so on the facts of this case and concluded that the relationship between the religious institute and the teaching brothers was not, in fact, just sufficiently akin to that of an employer and employee, but was actually closer than that of an employer and its employees, so as to satisfy stage 1 of the test for vicarious liability. And there was never, in the light of Lister, much doubt about the application of stage 2. The Supreme Court made it quite clear that the law was, to use their words, quotes, on the move, close inverted commas. In other words, they were creating, in effect, new law. Now, quite a number of cases followed these 2 decisions, in particular the Supreme Court decision. But I'm not going to weary you with all of them, just 2. These 2 cases, both decided in 2016, Mohammed and Cox, were different sides of the vicarious liability coin. Cox was a claim arising out of an injury which had been sustained following the careless work of a prisoner who was employed, albeit on a semi-therapeutic basis, working in the prison kitchens. It was argued that the prisoner was not an employee in the conventional sense, and that therefore stage 1 had not been satisfied, so as to establish vicarious liability on the part of the Ministry of Justice, which was the government department with responsibility for prisons. The Supreme Court took the view that the prisoner's engagement was sufficiently akin to employment, and there was thus vicarious liability, stage 2 having been satisfied. Now, the Mohammed case was a much more controversial decision by the Supreme Court. Mr. Khan was employed as a petrol station attendant, A motorist went into the sales kiosk and asked, for reasons that are not entirely apparent, if some documents he had could be printed. Mr. Khan refused this request and ordered the motorist to leave using racist and threatening language, and followed the motorist back to his car, opened the door, and ordered him never to come back again, using threatening language in the process. When the motorist told Mr. Khan to close the door, Mr. Khan then assaulted him. Now, the judge at first instance decided that Mr. Khan's actions were beyond the scope of his employment. An appeal to the Court of Appeal was dismissed. They agreed with the judge. They decided that the employer had employed the wrongdoer and that the wrongful act was I should say it was the Supreme Court took a different view, and they decided that the employer had employed the wrongdoer and that the wrongful act was within the area of his authority given to him, and that in those circumstances it was fairer that the employer should suffer, in effect financially, for the wrongdoing than the person who was wronged. The relevant question, in the view of the Supreme Court, was whether the functions, or to use their expression, field of activities, were wide enough to mean there was vicarious liability on the facts. If there was sufficiently close a connection, then, and I quote, the court must decide whether there was a sufficient connection between the position in which he was employed and his wrongful conduct to make it right for the employer to be held liable under the principle of social justice. And then the court referred to various cases. The invocation of social justice perhaps indicates that the courts were trying to approach this in a general sense of what might be fair on the circumstances. The court pointed out that Mr. Khan's job was to attend to customers and to respond to their inquiries. Although his conduct in answering the claimant in a foul-mouthed way and ordering him to leave was inexcusable, it was nevertheless, so they said, within the field of activities assigned to him. The court did not think that his acts, although motivated by something personal between the two, and a gross abuse of his position, had taken him outside the scope of vicarious liability because of what they described as the temporal connection, i.e. all part of this that happened at the same time, and the unbroken sequence of events culminating in the abuse. Lord Toulson, who gave the leading judgment in the Supreme Court, made one observation which caused considerable difficulty in clarification of the law in a subsequent case. He said this: Mr. Khan's motive is irrelevant. It was obvious that he was motivated by personal racism rather than the desire to benefit his employer's business, but that is neither here nor there. So in 2016, the law was not, I respectfully suggest, particularly clear. There were these 5 tests, general tests, which, although the court said were still the law, they emphasized in Cox and Mohammed, they shouldn't be read like a statute. They were just some indication of the circumstances. But in the view of a large number of legal commentators, the law had been left in a pretty uncertain state. So let me now turn to the final act in the story and the 2 cases which should be in the next slide. Barclays Bank and Morrisons Supermarket, who featured once again on very different facts in cases before the Supreme Court. And they too were cases which looked at different aspects of vicarious liability. Stage 1 was the Barclays case, and stage 2 was the Morrisons case. The same panel of judges heard both cases, and no doubt it was thought sensibly that it was better that there should be a clear and consistent approach to the law. So you had the same panel of judges having regard to the huge number of cases which were reaching the courts at various stages, and the general confusion that appeared to have emerged as a result of the Christian Brothers case, and indeed in the Mohammed case. So let me start with the Barclays case. Now this case arose out of allegations by a large number of women who said they had been sexually assaulted during the course of a medical examination, which was part of the pre-employment process. Barclays were, some 30 or 40 years ago, in the habit of employing school leavers with suitable educational qualifications to work in their branches. Now, very often this meant a lifetime's employment. And part of the checks that were carried out of a prospective employee included a medical examination. It was usually, but not invariably, carried out from this particular branch of Barclays in Newcastle by a general practitioner, Dr. Bates, who lived in the suburbs of Newcastle, and in a way that was common then and is still common now. He carried out his practice in an adapted part of his house, adapted into the form of a surgery. Now, Dr. Bates had long since died by the time the litigation commenced. It's an irony that had he been sued much earlier, then he might have been liable, but he would have been liable if they'd been able to prove the abuse. But Barclays, on the state of the law, would not have been liable because of the old position of somebody having committed a criminal offence being on a frolic of their own. So that was one of the reasons why the claim was so late in coming. Now, Dr. Bates's estate had in fact been distributed, he having died some time ago, and it was probable there wasn't any relevant insurance because insurance cover was restricted and didn't cover deliberate acts of abuse. Now, the Barclays litigation involved, on the direction of the judge, a preliminary point, which was whether Barclays were responsible for the alleged abuse by Dr. Bates. Now, Barclays argued that he was at all material times an independent contractor. They said they had no idea that he'd been abusing young women in the course of his medical examinations, and indeed it wasn't the case that they didn't know. But the lawyers for those claimants argued, on the other hand, that in view of those 5 tests which you saw in the slide, as set out by the Supreme Court in Christian Brothers, it didn't matter that he was once what might have been termed an independent contractor, because the law had changed, or to use the expression that the Supreme Court had used earlier, it had moved on. Why, it was argued, should innocent young women not have a claim against Barclays, who had required them to have this medical examination? It would never have taken place had it not been for their prospective employment by Barclays, and they were given no choice as to the identity of the doctor who was to carry out the examination. Barclays, they argued, were in a much better position than anyone else to pay compensation, and therefore it was fair, just, and reasonable that they should do so. Now, these arguments were successful before the judge at first instance and then before the Court of Appeal, so they won. The matter then proceeded to the Supreme Court, where it was argued that although the law had been described as being, quote, on the move, it had not moved so far as to take away the so-called independent contractor defence. The lawyers for the various claimants said that in effect the old independent contractor defence was old law, and it was necessary to look much more widely at what would be a fair result, having regard to the relative positions, the power of the bank, and the relative lack of power of the various claimants. The Supreme Court, however, concluded that although there had been much movement in the law, and I've indicated to you by discussing those various decisions, the law had not, they said, moved so far as to take away the independent contractor defence. The court noted that these pre-employment examinations were only a part of what Dr. Bates did. He also carried out insurance examinations. He worked part-time at the local hospital and even had a newspaper column. He had given up conventional GP practice, but he had a wide variety of different sources of income. And in fact, the amount that he received from examinations carried out for Barclays varied very much from year to year. depending on how many people they were employing, and often formed a relatively minor part of his income. Now, Barclays didn't, of course, control the way in which he performed the medical examination, albeit that he used a pro forma to tick various boxes and make various comments, and that pro forma had Barclays' stamp on it. So it was argued that, therefore, Barclays were directing the way in which he carried out his work. Now, this argument didn't persuade the Supreme Court, who accepted that he was effectively acting as an independent medical practitioner. So the result is that if on the facts someone is injured by the acts of someone who is properly regarded as an independent contractor, then, albeit that an employer has caused the independent contractor to be engaged and put them in the position where they could, at least in theory, cause damage to claimants, there will be no vicarious liability. It is important, however, to emphasize that the courts will nonetheless be astute to consider whether or not, on any given factual scenario, the tortfeasor is properly regarded as an independent contractor. Now, many of the recent cases in all sorts of contexts have remarked on the development of the so-called gig economy, where it suits employers and sometimes employees too to have arrangements which are labelled as self-employment or engagement as independent contractors. But there may in reality be at the heart of the relationship a conventional employer-employee relationship. For example, if someone works only for one person, they have little freedom on the terms and conditions of their employment. They will probably be regarded in truth as an employee, albeit that they may not have the security of a conventional employment relationship. And in those circumstances, a court is most unlikely to conclude that there is some form of independent contractual relationship. Similarly, where there is a relationship which does not fit neatly into an ordinary employment description, such as the priest in English or a teaching brother in Christian Brothers, then the courts may find that the relationship is, quote, akin to employment. What I think is clear from the Barclays case is that the law still has some structure, and that Lord Phillips's test does not mean that all the old distinctions and all the old law has disappeared. I should perhaps just add one thing, which is that I was the barrister who acted in the Christian Brothers case. We won the case at first instance. We won in the Court of Appeal, but lost in the Supreme Court. I was also the barrister acting for Barclays Bank. We lost the case at first instance. We lost the case in the Court of Appeal, but won in the Supreme Court. That's quite an unusual course for a case to take, but I think ultimately the law has got some more shape and more, it's much more readily comprehensible than it was before. So let me move now to the other case, which the Supreme Court considered and gave judgment on the same day in April this year, the Morrisons case. And I think this case is possibly of even more practical importance in the future. Mr. Skelton was a senior auditor for Morrisons, and he'd had some minor disciplinary issue with the company, and he developed an irrational grudge against them as a result. As a senior auditor, he was, back in November 2013, required to hand over payroll data for an external audit. Now, he kept a USB stick with all this information, which concerned no less than 98,998 employees. And he uploaded it in a way that was untraceable onto the internet. He used the username and date of birth of a fellow employee to create a false email account in a deliberate attempt to frame that employee. The email was linked to a pay-as-you-go phone, Mr. Skelton then deleted the data from his work laptop. Now, on the day of Morrisons' financial results, they were due to be announced, Skelton sent CDs containing the file anonymously to 3 United Kingdom newspapers. He said he was a concerned member of the public who had found the file on a file sharing website. Now, the newspapers didn't publish the data, but one of them alerted Morrisons, who immediately removed the data from the internet, instigated internal investigations, and informed the police. Now, in due course, Skelton was arrested, and he was in fact sent to prison for a total of 8 years. Morrisons spent more than £2.26 million in dealing with the immediate aftermath of the disclosure. The claim that came before the courts against Morrisons was from many of those who had suffered as a result of the disclosure, alleging misuse of private information and breach of confidence. The claimants wanted damages in respect of the alleged distress, anxiety, upset and damage they had suffered as a result of the disclosure. The trial judge had to consider arguments on the scope of the Data Protection Act and the duty of confidence. But for our purposes, the relevant legal question was whether there was vicarious liability having regard to the deliberate criminal acts on the part of an employee, Mr. Skelton. Was there a sufficiently close connection between what he did and his employment? Now, the judge at first instance borrowed the language of the Mohammed case, the man who was engaged to work at a kiosk at the petrol station, and considered that the data was, quote, a seamless and continuous sequence of events, the very language that was used in the case of Mohammed. The judge added that Morrisons had trusted Skelton to deal with the confidential information and took the risk that it might be wrong in placing their trust in him. The judge also concluded that the 5 factors listed by Lord Phillips in the Christian Brothers case were all present. The Court of Appeal dismissed the appeal, agreeing with the judge for essentially the same reasons. The Supreme Court took a wholly different view. The claimants placed particular reliance on Lord Tilson's remarks, which I referred to earlier, that motive was irrelevant when dealing with Mr. Khan's activities outside the petrol station kiosk. But the Supreme Court did not read Lord Tilson as saying that in any circumstances motive was irrelevant. Rather, they thought that what Lord Tilson was considering was the closeness of the connection, and they weren't distracted by the fact that he may have had some collateral motive for doing what he did. So the Supreme Court, having examined the previous law with considerable care, concluded that the disclosure of the data on the internet was not part of the functions that Mr. Skelton had or his field of activities in the sense in which the words had been used in Mohammed. It was not an act he was authorized to do, and the fact that all 5 factors in Lord Phillips's list were present was nothing to the point. Those factors were not concerned with the question of whether the wrongdoing in question was so connected with employment that vicarious liability ought to be imposed. Rather, they said, with a distinct question of whether or not, in the case of wrongdoing committed by someone who was not an employee, and if the relationship between the wrongdoer and the defendant was sufficiently akin to employment as to be one in which the doctrine of vicarious liability should apply. In other words, this case was a stage 2 case, whereas Lord Phillips was talking about stage 1. And that was something of a change in the law, because Lord Phillips had suggested that in looking at vicarious liability cases, you should often engage in an analysis, which is something of a synthesis between stage 1 and stage 2. No longer the case after what the Supreme Court said in Morrisons. The Supreme Court also accepted that there was a close temporal link and an unbroken chain of causation linking the data to Skelton for the purpose of transmitting it and disclosing it on the internet. But a temporal causal connection was not of itself enough to satisfy the close connection case. And finally, they said, the reason why Skelton acted wrongfully was not irrelevant. On the contrary, whether he was acting on his employer's business or for purely personal reasons was highly material. And I think it must be said that that decision probably means that the Mohammed case must be looked on with some considerable reservations, as courts are wont to do. In other words, although they didn't say so, it may well have been wrongly decided. The decision of the Supreme Court in the Morrison case has, together with the Barclays decision, marked a considerable retreat from what was a legal position of some uncertainty. Many academic lawyers had argued that the companies might be liable for almost anything their employees did, or even those who might not normally be regarded as employees. They might also be liable, whatever the nature of the task they performed. That is no longer the case. So what then is now the law? For vicarious liability to exist, there must be a relationship of employment or something akin to employment. If the wrongdoer is genuinely an independent contractor, then there will not be the relevant relationship. But the courts will still be careful to examine the reality rather than the label put upon the relationship. So that's the stage one question. Now, providing, and this is stage two, there is an appropriate relationship of employment and stage one is satisfied, the question for the court on stage two will be whether or not there is a close connection between the act complained of and the employee's employment or his authorised acts, so as to be considered as within the scope of that employment. Now, the closeness of the connection will be very fact-specific. But if an employee like Mr. Skelton has some personal grudge and his employment simply provides him with the opportunity for wrongdoing, that will generally not be enough. And that's perhaps particularly important given the possibility of some cyber sabotage in all sorts of circumstances being perpetrated by an employee. Although more clarity is now, I think, there in the law following these two recent Supreme Court decisions, there will still be cases on the margin, as there always have been, and Lord Phillips's tests are still of relevance, although their application has been modified or qualified by the Barclays and Morrison decision. And it's certainly no longer enough to say, well, an employer should have to pay because they have deeper pockets and are more likely to be insured by the tortfeasor. Now, one final point should be emphasised, and you see that in this slide there is another section which is other basis of liability. One final point should be emphasised, and that is that vicarious liability assumes no fault on the part of an employer. The liability attaches to him simply because the law says that if you employ someone in appropriate circumstances, you should bear the burden of liability for their acts, as well as obtaining the benefit of their contributions to your economic or other success. But it may well be the case that on particular facts, an employer has allowed his employee to act, or at least taken insufficient care to prevent them acting in a way as to damage third parties. In which case, those third parties need not rely on vicarious liability to sue, but can simply rely on negligence or some other tort which involves some deliberate or negligent act on the part of an employer. So this means that it's still incumbent upon an employer to take appropriate care to prevent deliberate wrongs being perpetrated, and, for example, to have in place sensible security systems to prevent rogue employees damaging third parties. Finally, it's worth standing back from the subject of vicarious liability and viewing this series of cases as a very good example of how judges develop the law. There appeared to be a stage in the Christian Brothers decision where the law was moving towards a position where liability was almost strict on the part of an employer for the wrongs of his employee, with a fairly elastic interpretation of what was regarded as akin to employment. And when they said that the law was, quotes, on the move, end quotes, what the Supreme Court were really saying was that they thought it was about time it did move. The courts are no doubt and rightly influenced by the change in working practices and the thought that it would be fair to place the burden on employers, fairer, than to risk those that have been damaged by the acts of an employee leaving a court empty-handed. The courts realised that this expansionist view lacked structure, coherence, and indeed made the law very unclear. So it was time for an orderly retreat to move back to a more coherent and workable test of vicarious liability. That's the position that we're now in, and I believe it's the position that judges of the AIFC would adopt were a dispute involving vicarious liability to come before them. Thank you very much.